Welcome to the second episode of Season 2 of Community First, where we have legal and social conversations with the community. I am Mame Banya Iduamwa, a Senior Legal Associate at BNP Associates, and I will be your host for this episode. I'm sure you're itching by now to know what we have for you today. Well, our theme for today is Harmony and Dispute, Navigating Alternative Dispute Resolution in Ghana. At the end of today's episode, we hope to uncover the concept of alternative dispute resolution or ADR, the various types of ADR processes, the advantages and challenges associated with the use of ADR mechanisms, the various ADR institutions, programs, and initiatives that exist in Ghana, as well as the future of Ghanaian judicial system as complemented by ADR. To help us unpack this very important topic is a legal luminary who has expertise in domestic and international arbitration practice. He has served as a sole arbitrator, co-arbitrator, and chairman in several domestic arbitrations under the rules and procedures of the Ghana Arbitration Centre and the Alternative Dispute Resolution Act 2010. Act 798. He has been a leading counsel in major international arbitrations involving state parties and multinational companies under the auspices of the London Court of International Arbitration and the UNCITRAL rules. He is the administrator of the Ghana Arbitration Centre and a panel member of arbitrators for the International Centre for Settlement of Investment Disputes, ICSID. Washington, D.C. He's also a member of the London Court of International Arbitration Africa Users Council. He's a lecturer in ADR at the Ghana School of Law and an adjunct lecturer at the University of Ghana Law School, Legon. He is the country correspondent for Ghana in the second edition of Arbitration in Africa, a practitioner's guide, whose journal editor is Lise Bosman. He also authored a chapter on Ghana Arbitration Centre in Onyema Emilia's The Transformation of Arbitration in Africa, the Role of Arbitral Institutes. He is the founder and managing partner of Amofa and Partners. If you haven't already guessed who our guest for today is based on this elaborate portfolio, I'm sure my last statement should give you a cue. Ladies and gentlemen, today I have the singular honor of hosting none other than Mr. Emmanuel Amofa on this episode of Community First. Community First welcomes you, Mr. Amofa.
Thank you, Mommy.
So, we'll get right into it without wasting much time. We want to start off by first letting us know what alternative dispute resolution is in simple terms.
Yeah. Thank you once again for the opportunity. And it's heartwarming that you are engaging in this community activity, and I'm happy to be part of it. Alternative Dispute Resolution Mechanism, or ADR as it's simply known, is any method of resolving disputes other than through the court or through the judicial system. Okay. So if you settle a dispute through any system other than through the court, then you are talking of alternative dispute resolution. So as the name implies, it is an alternative to the court system.
Okay.
Of course, if you go and take machete to chase people to resolve it, it's not alternative dispute.
Okay.
It's a civilized way of resolving dispute other than through the court system.
Okay.
Yes.
Emphasis on civilized way of resolving disputes.
Yes.
Okay. So what are some of the different types of ADR processes that are practiced generally?
Okay. Mainly, we have four known practices in Ghana. One is to settle your dispute through negotiation. Two, you may also adopt mediation to resolve your dispute. Then there is arbitration.
Okay.
And then the last one is customary arbitration.
Okay.
These are the main ones, but there are other hybrids that are also used. But these are the recognized ones that we use in Ghana.
Can you run us through these four that you've mentioned? What exactly goes into them?
Okay.
Briefly.
All right. Negotiation basically is between two parties. That if two parties have a dispute, they will engage in communication with the aim of resolving their dispute. Okay. So I can have a dispute with you. We don't go to court. We don't call anybody. we sit together and try and find out if we can resolve our dispute. That's negotiation. So that distinction is very important. We must always bear in mind that in negotiation, it is between the parties, the two parties. All right. Then we come to mediation. Mediation involves a third party neutral.
Okay.
Or it could also be two persons, but they must be neutrals.
Okay.
Their role is only to facilitate the resolution of the dispute. They will help the parties to arrive at their own settlement.
Okay.
They will not impose the decision on the parties. They help the parties to attempt to resolve their dispute. So in mediation, you have the introduction of a third party neutral or neutrals.
Okay.
That's mediation. Come to arbitration. Arbitration involves also a third party or third parties. They could be one, they could be three, but they cannot be two. Immediately there's a distinction between that one and mediation.
Okay.
In the case of arbitration, the neutral or third party actually makes a decision which binds the parties.
Okay.
Okay. And in the case of arbitration as well, the third party neutral determines the rights of the parties.
Okay.
It is not based on the parties' mutual decisions. It is how the third party neutral sees it, and that makes a decision which binds the parties. But it can't be three, and I'm saying it cannot be two, because three parties, you always need a majority or unanimity. That's why you have three or one. Okay. Then we come to so the another characteristic of arbitration that the decision that is arrived at is final and binding on the parties.
Okay.
You come to customary arbitration, which has a semblance with the arbitration that I just talked about, but this is one that is practiced at the community level.
Okay.
But you can enter into customary arbitration orally. Okay. The arbitration that I talked about, it must be in writing. This one, it can be in writing, or it can be done orally. Okay. But the decision which is arrived at is also binding in customary arbitration, but it's normally used in our respective communities.
Okay, so customary arbitration can happen, for example, in a chief's palace.
In a chief's palace, in the Odikro's hut, in the family heads and other things. Yes.
Okay, so from what you've described right now, negotiation is the only one that the two parties themselves can deal with the matter and try and settle it.
Absolutely.
But all the others, they have
a third party. Yeah.
Okay. So basically, you've just given us a sense of how these ADR practices work. Now, can you give us an overview of the Ghanaian legal system and the place of ADR in the Ghanaian legal system?
In the Ghanaian legal, okay. Happily, the legal system recognizes ADR.
Okay.
It is now an integral part of the justice delivery system in Ghana. So you have a whole statute dedicated to ADR. And this is the Alternative Dispute Resolution Act.
Okay.
That is the legal framework for ADR in Ghana now. Beyond that, we have other statutes like the Courts Act, which makes provision for the parties to settle their disputes through ADR mechanisms, either mediation or negotiation. Is the Courts Act does that.
Okay.
And one important statute which now bolsters ADR is the amendment to the Courts Act, the Civil Procedure Rules.
Okay.
And it is CI 133. Now it gives parties the opportunity at the level what we call the directions. When you are taking directions in court, the parties may indicate their willingness to resolve their disputes through ADR.
Okay.
And if they do, the court must stay proceedings and refer the parties to ADR. That is not the only statute. There are a number of statutes. I can't mention all. You have the Banks Specialized Deposit Taking Institutions Act. You have the New Lands Act. You have the Ghana Free Zones Act. You have the Public Utilities Regulatory Commission, the Labor Act. A lot of them. In all of these legislations, there are provisions which allow for parties to engage in ADR.
Okay.
Yes.
Okay. So basically, Ghana encourages the use of ADR mechanisms
Absolutely,
to resolve
yes,
disputes.
yes.
So when it comes to the courts, how have the courts received the use of ADR mechanisms as well? You've mentioned a number of provisions in some of our acts that allow that, but is it the case that it's only when the parties want to, that they tell the court that maybe we want to resolve it by ADR, or there's some mechanism in place for the court to also say go to?
There is, and that you can take an inspiration from the ADR Act itself.
Okay.
There's provision there, in I think section 7, section 7(1) of the ADR Act, and then section 64 of the ADR Act allows a judge, if he thinks in his opinion that a matter before him is one that you can resolve through ADR, then the judge may, with the consent of the parties, refer the parties to arbitration or mediation, or even customary arbitration. That opportunity is there for the courts to do, for judges to do. But that's not even the only thing. The court itself, the judiciary, has set aside a period where it is known as the ADR week.
Okay.
During the ADR week, the courts will encourage parties to attempt to resolve their dispute through ADR. The critical thing for us to know is that in all of these, the courts are not imposing their will on the parties. It is a suggestion that there is another way of resolving your dispute, and it is through ADR. And that week has been set aside to encourage parties to explore the opportunity of settling their dispute through ADR.
Okay, so basically, if the parties don't consent to settling by ADR, the court cannot.
The court cannot. They cannot. In fact, if you go through the ADR process and you are unsuccessful, you can still go back to court.
Okay.
Yes.
Okay. So we've talked about the different ADR mechanisms, how it's received in Ghana. Is it everything or just any case that can be resolved by ADR in Ghana?
Yeah, that's also a very good question. It is not every case that you can submit to ADR.
Okay.
The type of cases that you can submit to ADR are circumscribed, or they are determined by law. All right. So in commercial disputes, in family disputes, and disputes relating to tenancy and all that, you can't submit to ADR. But you cannot submit criminal cases which are of aggravated nature, like felonies, to ADR.
Okay.
So for our listeners, or for those who will be listening to this, don't say that they say ADR, you can use ADR. So if you go and steal, then you think that you can go to ADR, or that you engage in rape or some other, then you go and call people and say, oh, let us go to ADR, because BMP said in the community podcast that, no. If it is of aggravated nature, criminal cases, you cannot.
Okay.
If it is a criminal matter, so that's the distinction, but it is a misdemeanor.
Okay.
And let's say landlord and tenants, and there's some altercation in the at the house or something, and then there is a dispute, and then somebody hits someone, which is a misdemeanor, is defined by law.
Yes.
Then that matter, when it goes to court, the court is encouraged to tell the parties to try and
settle.
resolve their disputes. Yeah.
Okay.
But otherwise, not every matter can be resolved through ADR.
How about issues involving, say, the environment?
Well, the issues of environment you cannot,
Okay.
because that's also determined by law.
Okay.
The ADR Act says in Section 1 that certain matters cannot be resolved through ADR. Environment, issues of constitutionality, interpretation and enforcement of the Constitution, you cannot. And then the last one is very instructive. Any other matter which by law cannot be settled through ADR, you cannot. So that for the category will include criminal cases which are of felonious nature.
Okay.
Yes.
Okay. And also another question: can all the 4 methods of ADR that you've discussed today, can they all be employed to settle one dispute? So negotiation, mediation, arbitration, customary arbitration. Can we say this dispute, I want to try all 4? Is that possible?
You want to try
All the 4 methods, all these 4 mechanisms to try and settle this matter via ADR?
there may be distinctions. Okay, so let me give you a very typical example. If it's a commercial dispute, trading dispute arising out of commerce and trading, you can try negotiation. It can go through negotiation. It can go through mediation. You can attempt arbitration, whether customary or arbitration in general, you can. But take a case of a marital dispute in which, for instance, a party wants a dissolution of the marriage. All right?
Yes.
You cannot go to arbitration because an arbitrator cannot dissolve a marriage.
Okay.
That is outside the purview or the powers of an arbitrator.
Okay.
But that matter can be resolved by means of mediation.
Okay.
Not dissolving the marriage, but reconciling the parties.
Okay.
So whilst in mediation, you can engage the parties with a view to resolving the dispute, but not granting a dissolution of the marriage.
Okay.
In arbitration, you cannot submit that to arbitration.
Okay.
So in that way, not every dispute which is amenable to some of the ADR processes can be resolved with other of the mechanisms.
So it basically depends on the matter that you're trying to resolve.
Yes.
Okay.
Yes.
Okay.
And in fact, you see that those who are engaged in settling marital disputes in court, there is a provision in the law which requires you that you show that you have attempted to reconcile the parties.
Yes.
That is through one of these means, either negotiation or mediation, but certainly not arbitration because of the
nature of
arbitration.
Okay.
Yes.
Okay. Are there any key cultural or historical factors that have shaped the adoption of ADR in Ghana?
Oh yes. You can immediately think of customary arbitration.
Yes.
That we did not just adopt ADR, or that ADR is not a recent phenomenon that we have latched onto it. No, because in the past we were settling our disputes through adjudication, through customary arbitration. We had mediation and we had negotiation and all that. You see, so that has always been with us.
A part of us.
Yes, if you look in the law reports, you date back, you see decisions on customary arbitration, which tend to show that people had interest in resolving their disputes other than going to court. So we have that practice in the past.
Okay. So it's not that we just borrowed it or stole it from them.
No, not at all.
Okay.
I think the other way around it will be preferable.
Okay,
that
they
rather borrowed
us.
it from us.
Okay.
I won't say they stole. they copied from us.
Okay.
Yes.
How have these mechanisms proven to be effective in resolving disputes in Ghana? These ADR mechanisms.
Yes.
How have they proven to be effective?
The point is this: if matters and all disputes are not resolved through ADR, I doubt if the courts can entertain the kind of disputes that we have in the country.
There are lots.
Most of the cases have been taken over by customary arbitration, arbitration in other areas, negotiation. So all I'm saying is that there are a number of disputes which have been resolved without reference to the court. Yes. So it has an effect on the entire justice delivery system. Even now, we still complain about congestion in the courts. So what would be the situation if ADR does not complement the court processes? Then it means that the judges will still have more work to do. Yeah. So it has played an effective role in reducing the number of cases that go to court. Yeah.
Okay. Are there any success stories that you can share with regards to the use of ADR?
Oh, in my own
Your
experience,
yes.
oh yes, I have a lot. When parties even decide that they will use arbitration, the nature of arbitration is that one person is seeking to win, or both of them are seeking to win, but the outcome will be that one person will win, then another will lose.
Yes.
That will be the outcome.
Yeah.
But even during arbitration, we have tried to use mediation or negotiation to settle.
Okay.
So this is what happens.
Okay.
The parties appear before you, and you look at the matter and you think that this is not a matter that they should go through arbitration to settle, to have one party win.
Yeah.
So if you look at it that way, you encourage the parties to try and use either negotiation or mediation to settle.
Okay.
And in most cases, they have adopted negotiation, and then they say, we have finished. This is our settlement. Enter it as a consent award for us. That's it.
Okay. So the parties come to you with arbitration,
But
you're able to speak to them, and then they decide that they'll settle with either negotiation or mediation.
Yes.
Okay.
And then sometimes, in my role as administrator of the Ghana Arbitration Centre, they come to the center, and you see there's sometimes confusion between arbitration and mediation. They'll come to the center and say, please, I have a matter, I want arbitration. But you will see that it is not really arbitration because of the misunderstanding about the concept. So you explain it to them, say it is mediation. So get a third party to help you to facilitate. When they agree, it succeeds in such cases. Sometimes you also advise them, look, this is a matter, try and talk to the other party, and then it settles it. Yeah. So these are some of the experiences that I can share with you.
Are you able to share a particular story without necessarily mentioning parties?
Yes. Let me see how far I can go. But of the confidentiality.
Yes.
So there is a case, it's been settled now.
Okay.
The parties came to the center, they appointed me as arbitrator, and they filed their documents. But the interesting thing is that the respondent owed the claimant.
Okay.
He did not file anything.
Okay.
He appeared before the tribunal, and he demonstrated a willingness to, one, submit to the arbitration process, but more importantly, to settle the matter.
Okay.
So I encourage them to be engaging in negotiation.
On the side?
On the side.
Okay.
So occasionally they will inform the tribunal, this is the extent to which we have gone, there are lapses here and all that. And finally, they've agreed and signed terms of settlement. That's it.
Okay.
Yes.
So it looks like most of the time what you do is more to encourage the parties to try and just reach a settlement.
Yes,
on their own. They are
exactly,
able to come to that
because
position.
your role as arbitrator is not to settle the matter in terms of the parties coming to win, because one party, as I said, you are looking at the rights of the parties. So leave that aspect to them, but let them know that apart from arbitration, there is also a way in which they can settle their dispute. use arbitration, use negotiation, or if you like, mediation, and then have the matter settled.
Okay.
Yes.
Okay. What are some of the challenges that you have encountered in implementing ADR?
They there are a number of them,
Okay.
but the most fundamental one that I can mention is the attitude of some lawyers. But fortunately, let me add that one. Fortunately, that approach is changing.
Okay.
There are some lawyers who think that the only way to resolve a dispute is through the court. And remember that when a person has a dispute, the first point of call, if it is not a criminal matter, is to look for a lawyer.
Yes.
Now, if you go to a lawyer who is court-minded and you tell the lawyer that this is my story, I'll file a writ.
Yeah.
That is a stab at the back of ADR.
Yeah.
I think that the first approach will be to see, is there a way that we can settle this matter rather than going to court? Okay, so that attitude, if it does not change, will keep on increasing the number of cases in court. Yes.
Okay.
2, the other challenge has to do with the parties themselves. Some people think that if you adopt ADR, then it means that you don't have a case. You have a weaker case, and therefore that is why you are looking for other system. But if you go to court, take the person to court, let the person through the mill, then it means that you have a case. No. But that's also a wrong perception. So, and therefore, it does not encourage people to adopt ADR. When you may have a case, but you can still use ADR to resolve it. When you use ADR, it does not mean that your case is weak. It doesn't mean that at all. So these are the things which deter people from using ADR. But there are other challenges, but these ones I can mention to be the things which prevent people from even taking the step to resolve their disputes through ADR.
Okay. And when people actually do take the steps, are there any other challenges you face in resolving the disputes through ADR? Any challenges in that arena?
Well, it can only mean the approach during the either negotiation or mediation. Sometimes people go to these systems thinking that because you have a case, they are unwilling to compromise. Okay. Now, one thing you must know is that the practice of ADR is also skillful. There are techniques that are used in resolving this. But if a person has a mind that I have a good case and therefore ADR must grant me what I think I should get in court, then you see that the process will crumble. The parties will not reach a settlement, and then therefore they may end up still going to court. So there is the attitude of persons in ADR which sometimes compromises the process of ADR.
Okay.
But it will also depend on the neutrals which are involved in these things. Because I say it is techniques and skills, people must use these techniques and skills to let the parties understand the process and try and come to a settlement of a sort. Yes.
Okay. Are there any initiatives and programs that are at maybe government level to try and promote ADR awareness and education in Ghana?
At the governmental level, I can only associate the effort of the judiciary in promoting ADR by the ADR week.
Okay.
That is one. The proactiveness of the judges themselves in referring parties to ADR. that is also one way that we can promote ADR. Yeah, but the one challenge I think which must be mentioned is that if you look in the ADR Act, the government is to set up ADR centers in various communities. So if these centers are set up in the various communities, it will gradually move people from the courts and gravitate towards the centers to have their disputes settled. But these centers are not set up yet. So I'm hoping that in future they will set up. And if they are set up, then it is also will be an encouragement for the settlement of ADR in that regard.
So you mentioned these centers. As the government hasn't set up centers yet, are there any institutions that provide some of these ADR mechanisms within Ghana?
Oh, yes. Fortunately, some of us are filling the gap. The Ghana Arbitration Centre has been doing this thing since 1996.
Wow, that's a long time.
Yes, 1996 or 97, when it was set up, trying to promote the settlement of arbitration. And it is not only just providing the forum, education. The center has been holding series of seminars, education across the country. So that gives people an idea of what ADR arbitration is and other ADR mechanisms. It is not only the Ghana Arbitration Centre. There is GACMA, the Ghana Association of Chartered Mediators and Arbitrators. They've also been doing that. They have been concentrating more and more on mediation. Yes. There's recently been established the Ghana ADR Hub in Kumasi, also taking care of matters in the northern sector and in the southern sector as well. And then I've heard that there's the Association of ADR Practitioners. So that's also been set up, and it's also to encourage people to join these bodies with a view to encouraging people to settle their disputes through ADR. But the most important thing is the collaboration that exists among these institutions, because the objective is one, to ensure that disputes are settled amicably without too much stress and pain on the parties involved in dispute. Oh, remember that when parties are in dispute, they are in pain. They want their dispute settled. And then you go through an elaborate process of dispute resolution. It makes it worse. Yes.
So have there been any collaborations between these institutions?
Oh, yes. We sometimes hold joint programs on ADR. You have personnel crisscrossing here and there to resolve disputes.
Are there any trends you foresee in the continued evolution and adoption of ADR in Ghana? Trends?
Yes. I think that with the emergence of these associations encouraging people to adopt ADR as a mechanism for resolving disputes, I see the future of ADR to be bright. And as I said, the continuing legal education, at least for lawyers as well, will be very key, because when parties come to lawyers and then they look at the matter and see that this is one that can be resolved through ADR, and then they refer parties to ADR, it is a major step in that direction, because the courts will now be free of the dockets and be dealing with matters that are more germane to their work, except dealing with matters that cannot be resolved through ADR will be the matters that we refer to. So I see the prospect, and also because of the fact that most legislations recommend the use of ADR as a first step
before you go
to court or adopt it. Then it means that the focus there now is ADR and not the other system, the court litigation.
Is there any overarching message or advice you'd like to give our listeners with regards to ADR?
The message that I will leave with those who will be listening or reading about this is that ADR 1 has not come to compete with the court. 2, ADR is only complementary to the court system. It is the court and the ADR are actually bedfellows.
Okay.
And therefore, people should feel free and adopt that mechanism for resolving dispute. The other matter I will mention, which I've said already, is that people should not think that adopting ADR is an indication that they don't have a stronger case. That's not it's not the case at all. They should always feel free to use that mechanism because it is expeditious and it will save them, most importantly, of their funds, cost, because it's less effective. Can you imagine that we have a dispute, we sit together and resolve it? You are not paying a lawyer. So all the costs that will go to a lawyer, and then the filing fees you pay in court and transport and all that are out
of the way.
Okay, so it is a way in which it brings efficiency in the resolution of dispute, always trying to make sure that the parties in dispute are happy. That will be my message to listeners.
Okay. Thank you so much, Mr. Amofa, for such a very interesting and enlightening discussion. I have my own key takeaways. I'll say what I've learned from today is that 1, ADR is a civilized way of settling disputes out of court. So don't think that if you go and take a machete to go and try and kill somebody, you're trying to use ADR. Also, there are varied ADR mechanisms, and depending on the situation, you can find the one that suits your matter. So next time you have a dispute, don't rush to court. Consider the ADR mechanism that could be available to you, and that might be a faster way of resolving your disputes, and you can go back to living your life as is. So, once again, thank you for coming on our show today and enlightening us. Until we come your way again, this has been Community First, where we have legal and social conversations with the community. Catch you on our next episode. Bye.